How's jail? Sucks.
It's not for me.
It's not supposed to. That's what I want to hear. You know? Do you speak Spanish?
That's right.
My mom used to tell me, Dime con quién andas, yo te digo quién eres. Tell me who you hang out with, and I'll tell you who you are. That's what life is. When you hang out with dogs, you're going to end up with fleas. I don't know if that's what's happening now, but I told you, I don't want you smoking.
Hold up, you hang out with dogs, you get fleas. This judge isn't pulling any punches today. But here's the real question. Should teens be judged by the company they keep, or should we give them more credit for independent choices? Drop your take in the comments.
And it's continued to happen. Now, should we do? Should we let him out? What do you think, Mom?
I agree with the same curfew. I want the same curfew he has. Everything, just maybe drug test randomly.
What do you think?
Yeah, I'd like to see him out. Number one, Judge. I mean, his mom, he's got asthma. I think he's learned he needs to be out of there. I think he understands using the friends as an excuse is not going to fly. Being around people that smoke weed, that ain't going to get you positive. I explained that to him. You know, based on the videos, which I watched, he needs to understand who you're hanging out with is the reason you're getting in trouble. Like Judge said. Okay?
You know, you have but one life. The more cases you start catching, the harder life gets. It doesn't get easier. The older you get bigger, fatter, uglier, you lose hair. Life doesn't get easier.
Okay, real talk. This just shifted from courtroom to life coaching real fast. The judge is warning about the slow grind of consequences. But did you catch it? No trade, no education, just cycles of jail and regret. This isn't just sentencing, it's a wake-up call.
And if you don't have a trade, if you don't have an education, you're going to end up in and out like all those other mopos in there now. Look at all the old timers in there. They're children who never grew up, never did anything with themselves, never amounted to anything. So all they do, they end up doing dope, they end up stealing that's not a life, man. You got a mom that cares.
You understand you're here because you got in a car of someone else driving that decided not to stop, right? You understand who you're hanging out with is getting you in trouble. They've now landed you in jail 2 times. You understand that, right?
Yes, sir.
The day you got arrested and now when the judge putting you back in. And you can blame your friends for the second time judge revoking your bond. But you need to understand you are putting yourself in this position by choosing to be around these people. So it's your decision how this goes. Okay?
Yes, sir.
I'm here to help you and get you out of this. But you got to help yourself. You got it?
Yes, sir.
Okay.
No hanging around with these people. It is a condition of your bond.
Sir.
I will give you another chance, but I will not play this game with you again. You continue to smoke. You continue to hang out with the...
And there it is, the bottom line. One more slip up and he's stuck like Chuck. That's not just colorful language, folks. Violating bond terms means no second chances, especially with random drug tests incoming. Think he'll make it 40 days clean.
people that you're hanging out with, or you pick up a new case, I'm going to put you in, and I will not let you out again. You will be stuck like Chuck until this case is over with. And I tell you, it takes 9 months just to get a damn 911 tape. I'm all over the state repeatedly because of it. Do you understand?
Yes, sir.
This is the last chance you have with me. Okay? I'll reinstate the bond today. Same conditions fly. We test him in 40 days again, 40 to 45 days. If you're dirty again, get ready. You understand?
I'll also give random drug tests too from the agency I work with, so just to keep up with.
Well, he's going to test with us. I want to know because I know.
No, definitely.
Right. Okay. All right, man. Make me proud. That's all I'm asking you to do.
Sir.
So what is he doing now? Is he in school or
Yes.
full time, right?
Yes.
Okay. All right. Keep it up.
And I'm gonna get a mitigation packet in here.
Done.
Okay.
All right. You're out today.
So much.
It's the last chance.
Yes, sir.
Okay, man.
Thank you.
You got it.
Reset when you,
Whatever you want.
okay, normal. Okay.
You are on bond for a theft, and now you've picked up another theft and an evading arrest. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On February 13th, officers were dispatched to a theft call at Lowe's. The officer spoke to the complaining witness, who's the loss prevention officer. The loss prevention officer stated that the defendant entered the store and put a speaker into his backpack. The loss prevention officer followed the defendant around the store. The defendant walked out of the store, passing all points of sale without
Hold on.
attempting to purchase the item.
Oh, you didn't?
Yeah.
I was gonna give him a coloring book. Okay, go ahead. So he's in Lowe's?
Yes.
All right.
The complaining witness attempted to stop the defendant. The defendant did not stop.
So let's get this straight. He steals a speaker, bolts from Lowe's, runs half a mile, hides in an apartment complex, and then resists arrest. Sounds like a GTA side quest gone wrong. What would you have done if you were the officer here?
The officer was on scene when the complaining witness was attempting to stop the defendant. The officer told the defendant to stop running, and the defendant did not comply. The defendant ran approximately half a mile from the Lowe's. The officer caught up with the defendant on the third floor of an apartment complex. The defendant attempted to resist detainment. The value of the item stolen was $129. And the defendant started to run from the complaining witness towards the nearby apartment.
Mr. Castillo, I'm gonna find that there's probable cause to go forward on your theft and your evading arrest. Deputy Miranda, case, you will now go into custody. I told you not to pick up any new cases. You've picked up 2 new cases. You will now stay with me. Goes with you.
I'm sorry about that, sir.
Can you appoint him a lawyer, please? I will appoint you a lawyer now, and we'll talk, but no, you can't continue. Unacceptable. Are you Jackson Norton?
Sir.
Mr. Norton, you are charged with 2 counts of assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
February 15th, officers responding to 1025 West Mass Parkway, bar Buckwild in Harris County, Texas, regarding a disturbance. The first complainant stated that he was located at the bar ordering drinks and was in a conversation with the defendant. After the complainant turned around and the defendant struck him on the right side of his face. A second complainant stated that he observed that the defendant was leaning over the first complainant, physically hitting the first complainant. In an attempt to break it up, the second complainant grabbed the defendant, and the defendant turned around and punched him on the side of the head. The second complainant stated that he believed he was unconscious for multiple seconds. When he woke up, he was lying on the ground. The defendant left the establishment where his bouncers were able to locate and detain the defendant in the parking lot. A witness, the bartender, observed a spill on the second complainant. The second complainant had injuries to the left side of his face where it was pink, and there appeared to be broken blood vessels under the skin, with a small laceration near the end of his eyebrow, where there was a small amount of blood. The first complainant advised he felt pain and had a small looking bump on the end of his elbow next to his eyebrow next to his hair.
So we have 2 assaults that were dismissed early last year. Any of the complaining witnesses the same?
No, Judge.
Same set of facts, whereas alcohol as well?
4 assaults. 4. And now the judge is done playing nice. With an ankle monitor, a booze ban, and a curfew, this isn't just about punishment, it's about protecting the public. But is this enough to stop someone on this path jury's out? What do you think?
The previous assaults happened at a high school graduation party.
But there was alcohol?
Yes, Judge, it's not like that was alcohol.
Mr. Norton, I'm now going to find that there's probable cause to go forward with your case. I'm now putting an ankle monitor on you so I know that you're not consuming alcohol. If I find that you do, I will put you in jail and I'm going to make your bond high. Do you understand?
Yes, sir.
We're now working on our 4th, so I will do everything in my power to protect my public at all costs. Do not use alcohol, do not use illegal drugs, no weapons, no going to any bars, clubs, establishments where it's 50% or more alcohol, no going out in the middle of the night. You will get a curfew as well.
Judge GPS. Whisper.
Sure.
Nine to 6.
Sure, yeah.
Judge, I leave earlier in the morning for work.
I'll give you a lawyer. I'll have the lawyer talk with you, work out any kind of detail, but my concern and my only concern is the protection of my city, and I'm gonna do it at all costs.
Yes, sir.
Do you understand?
Yes, sir.
Nothing else matters to me in this life right now. If I find that you're a danger, I only have one place for you.
Yes, sir.
Waive all the fees, please. Mr. Norton, I'll have you fill out an application for an appointed lawyer and I'll see whether you qualify. I'll have you go to Victoria, sign a reset. Deputy Miranda's going to give you an application. I'll have you take your seat in the jury box. Do not leave until you sign all the conditions. And then I'll take a look at the application, sir.
Yes, sir.
Jackson Norton, you just gave him bond conditions, and I wanted to know if we can amend the curfew because of his work.
Okay, I knew that he had issues. What would you like?
Judge, he'd just like to remove the curfew, but keep the restriction from any bars or alcohol, or places that serve alcohol, so that he doesn't go around there. But his
So
job
what I
is-
said is he cannot go to any establishment where it's 50% or more, where there's like a true bar. If he's going to like a Longhorn Steakhouse, if he's going to, Papacitos, that's okay. But if you're going to a bar like the Marquee or you're going to, that's unacceptable. No bars, nightclubs, anything of this nature, because I don't want him to, we're working on our fourth assault now. No, and so I don't want him out in the middle of the night. I'm willing to work with you on the curfew, but
So from what he's told me, he works 8-hour shifts, but he's also he's maintenance.
Here's something important. Curfews can be flexible, but only with documented proof. Judges aren't taking anyone's word for it anymore. In a system stretched, thin evidence beats excuses every single time.
So he can be on call and have to leave at 4 o'clock in the morning to get to work if there's an emergency. So he just wants to make sure that he won't be violating bond conditions if he has to go to work. If you can provide documentation that he.
right, I need proof because I'm not going to take his word for it. So bring me proof and then we can talk. But yeah, I'm not going to take his word for it that he gets up at 3 in the morning or 2 in the morning to go to this place and that place and, So, but show me something like that and then, yeah, we can work.
Okay, so we'll keep the curfew in place, and then if he needs to travel for work, we can provide proof that he's clocking in and clocking out.
No contact with any of the complaining witnesses, no weapons, and then,